This past March, New York State Police arrested two landlords, not a lawsuit, an arrest over something landlords across the country do to tenants all the time. Renters who don't know this stuff eat lockouts, junk deposit deductions, and revenge rent hikes worth thousands. In the next 10 minutes, the 5 things your landlord legally cannot do, the law behind each one, a real case, and the exact move you make when it happens to you. Number 5. Your landlord cannot just keep your security deposit. Every state regulates deposits, and the structure is usually the same. There's a deadline to return your money. 14 days in New York, 14 business days in Arizona, 30 days in many states, up to 60 in Alabama and Arkansas. There's a required itemized statement of deductions. And here's the line most renters have never heard. Normal wear and tear cannot come out of your deposit. Not in any state with a deposit statute. Worn carpet after 3 years, faded paint. That's the landlord's cost of doing business, not yours. Miss the deadline or skip the itemized list, and in many states, the landlord forfeits the right to deduct anything at all. Withhold in bad faith, and states like Arizona and New Jersey make it double damages. Texas and Colorado make it triple. In Florida, miss the deadline, and the landlord forfeits the right to touch your deposit at all. Think this is small time? In January 2023, the New York Attorney General forced Fairfield Properties, a Long Island mega landlord, to return over $422,000 in illegally withheld deposits to roughly 900 former tenants. The violation? Mostly the paperwork. No itemized list within New York's 14-day window, which under New York law means the deposit comes back in full. Your move? Photograph everything at move-in and move-out and request the itemized statement in writing. Small claims court exists for exactly this. Most people file without a lawyer. Number 4 sounds like something no landlord would dare do out loud. They do it constantly. And stay for number 2, the one with a per-day price tag written into the statute. Number 4, your landlord cannot retaliate against you for standing up for yourself. Here's the story that made this the law. Washington, D.C., 1965. A tenant named Yvonne Edwards reported her landlord, Nathan Habib, to housing inspectors. They found 40 sanitary code violations. Within weeks, Habib moved to evict her. In 1968, in a case called Edwards versus Habib, the D.C. Circuit said no. A tenant cannot be evicted as punishment for reporting code violations. That case birthed the retaliatory eviction defense renters in most states rely on today. Today, most states have statutes banning retaliation, the sudden rent hike, the non-renewal, the cut in services, after you complain to the landlord or a government agency, join a tenant organization, or exercise any legal right. Some states go further. California gives you a 180-day protected window after you complain. Inside it, a rent hike, service cut, or eviction can be attacked as retaliation, though you still have to show the motive. Connecticut goes further. Act against a tenant within 6 months of a complaint, and the law presumes retaliation. There, the landlord has to explain themselves. Your move: complain in writing every time and keep the dates. If a rent increase or eviction notice lands 2 weeks after your mold report, that timeline is your evidence. In many states, retaliation is a complete defense to the eviction itself. Number 3. Your landlord cannot discriminate against you. And this one is federal. The Fair Housing Act, 42 U.S.C. Section 3604, makes it illegal to refuse to rent to you, set different terms, lie about availability, or advertise a preference based on race, color, religion, sex, national origin, familial status, that means kids or pregnancy, or disability. This building isn't good for children is not a policy. It's a federal violation. And under the disability rules, a no-pets policy does not override a legitimate assistance animal. Landlords must allow reasonable accommodations. Federal courts have read sex discrimination to cover sexual orientation and gender identity after the Supreme Court's Bostock decision, and many states ban it outright, though as of 2025, HUD itself has pulled back from enforcing those claims. To be straight with you, there are exemptions. Owner-occupied buildings of 4 or fewer units, for one, though the ban on discriminatory advertising applies to everyone. And federal law doesn't cover source of income, so refusing Section 8 vouchers is legal federally. But more than 20 states ban it, including California, New York, New Jersey, Virginia, Washington, and Illinois. Now the price tag. The Department of Justice went after Joseph Santani, a New Jersey landlord with hundreds of units, alleging that for over 15 years he demanded sexual acts from tenants and applicants in exchange for housing. Sexual harassment of tenants is sex discrimination under the Fair Housing Act. In December 2021, Santani agreed to pay $4.5 million, including the maximum civil penalty the Fair Housing Act allows. It's the largest DOJ settlement ever in a housing sexual harassment case, and he was barred from managing rentals. Your move. A HUD complaint is free. Most people file without a lawyer, and you have 1 year. State and local fair housing agencies take complaints too, and a private lawsuit gives you 2 years, which brings us to number 2, the one where the legislature did the math for you. Number 2. Your landlord cannot cut your utilities to push you out the door. The power, mysteriously, goes off after a rent dispute. The heat dies in January. Lawyers call the tactic self-help eviction, making the place unlivable, so you leave voluntarily, and essentially every state bans it. If it happens, the law also lets you walk away and stop paying rent. That's called constructive eviction. California wrote the punishment straight into the statute. Civil Code Section 789.3. A landlord may not willfully cut water, heat, light, electricity, gas, or phone service with intent to end a tenancy, whether or not the utility is even in the landlord's control. The penalty is actual damages plus up to $100 per day, minimum $250, plus attorney's fees. Run the numbers. 30 days without power could mean up to $3,000 in statutory damages alone. That's why tenant lawyers love these cases. The statute does the arguing for them. Texas bars utility interruptions too, except for genuine repairs, construction, or emergencies. Your move. The tenants who document every day of the outage are the ones who collect, because in states like California, every day is money. And that leaves number 1. Remember that arrest from the beginning. This is why. Number 1. Your landlord cannot lock you out, remove your door, or put your belongings on the curb, no matter how far behind on rent you are. The rule, in state after state, the only lawful way to remove a tenant is a court judgment carried out by a sheriff. The case that set the modern template is Berg versus Wiley, Minnesota Supreme Court, 1978. A landlord changed the locks on a restaurant tenant, and the court called it wrongful eviction, upheld the damages, and declared judicial process the only lawful route. Courts nationwide followed. Some states went further. In New York, unlawful eviction is a Class A misdemeanor under RPAPL Section 768. A crime police can arrest for. Which is exactly what happened this past March when state police arrested 2 Crown Point landlords. Police say they entered a tenant's home without legal authority and removed their belongings. The charges, unlawful eviction and criminal trespass, are still pending, and they're presumed innocent. But in New York, a lockout isn't a civil dispute. It's a crime. Even Texas, as landlord-friendly as it gets, allows a lock change for unpaid rent only if the lease says so, and the landlord must hand you the new key on demand, day or night, even if you never pay the overdue rent. Refuse, and the tenant can win a writ of re-entry plus a civil penalty of 1 month's rent plus $1,000 and another month's rent if the landlord demanded payment first. And 2 myths. Dead. No written lease does not mean no rights. Month to month and oral tenants get the same court process. And an eviction notice, 3 days, 7, 30, however many your state gives, is not an order to leave. It's just the first step before a lawsuit. Until a judge rules and a sheriff shows up, that home is yours. Quick note: this is general legal information, not legal advice. The rules vary by state, so check yours or talk to a local attorney or tenant organization about your situation. Your landlord owns the building, but until a judge says otherwise, the law says the home is yours. If you want the rest of the fine print, they're counting on you never reading. Subscribe.